It's April 15th, tax day in the United States of America. Welcome to YesToHellWith.com. I'm Bo Johnson, and today I am once again with ChatGPT, and today we will discuss the question of what is authority. Now, in the LD order, the first question is always, by what authority? Before jurisdiction, status, standing, obligation, or enforcement can even be considered, before any of them, there must be a valid source of authority. The purpose is to distinguish between actual delegated authority and mere assertion, presumption, policy, custom, or force. For government and officials, good questions are designed to force them to identify the precise source, scope, and limits of their claimed authority. So today, ChatGPT, we're going to discuss authority. Good morning.
Good morning. I'm glad to be here for this conversation. Authority is such a foundational pillar. Let's dive into it. Feel free to lead with your next angle.
Well, Chat, let's go ahead and begin with your understanding of a comprehensive definition of authority, please.
Authority in the broadest sense is the legitimate or recognized right to exercise power, make decisions, or enforce rules. It's not just about having power, it's about having the rightful basis for that power. Whether that comes from laws, constitutions, consent of the governed, or other agreed frameworks, authority always begs the question: who or what grants you the right to do this, and what are its limits?
In a very general sense, would it stand to reason that most Americans as a sovereign people are inherently outside the scope of federal and state authority and statutes? I'm questioning that, and I'm asking you to answer.
In general, no. While Americans are a sovereign people in the sense that they collectively govern themselves through democratic means, the U.S. Constitution, ratified by the people, created a structure where federal and state governments have clear authority over individuals, provided they act within constitutional bounds. Personal sovereignty arguments that claim individuals stand outside all law or authority generally don't hold up in legal practice. The authority of government is derived from the consent of the governed, expressed through law. So while questioning authority is vital, legally, Americans are subject to those frameworks.
Okay, I get your answer. I'm sure some people would have some issues with it. Discuss and define sovereignty in general as the Supreme Court understands it, perhaps in Yick-Wo versus Hopkins, etc.
In general, sovereignty as the Supreme Court understands it is the ultimate authority to govern. In cases like Yick-Wo v. Hopkins, the court underscored that even sovereign power must be exercised within constitutional constraints. Sovereignty at the national level means the government's ability to enact and enforce laws. However, the court emphasizes that this authority can't be arbitrarily applied. In Yick-Wo, they made clear that equal protection under the law is an inherent limit. So sovereignty, while ultimate, must operate justly and within constitutional guarantees.
Speak to the sovereignty of the people, though. In what sense did Yick-Wo versus Hopkins guarantee the sovereignty of the people or recognize the sovereignty of the people as well as other Supreme Court precedents?
Yick-Wo v. Hopkins didn't speak directly to popular sovereignty in the abstract, but it affirmed that governmental authority, emanating from the people's sovereignty, must be exercised equally and constitutionally. The ruling struck down discriminatory enforcement of laws and underscored that no one, citizen or non-citizen, could be denied equal protection under the 14th Amendment. In that sense, the court ensured that governmental power, derived from the people, could not become arbitrary or oppressive. Other precedents like Marbury v. Madison established that the Constitution, created by the people, is the supreme law, limiting government. Sovereignty of the people means that governmental power ultimately depends on the consent of the governed. The court's role is ensuring that all exercises of authority remain within the boundaries set by that sovereign will.
So, in essence, if the people are sovereign and the laws are derived from the will of the sovereign people, then the capriciousness or arbitrary nature of governing officials and their application of law that is maligned against the interests of the people, that is not applied correctly, is the very heart of what we would say is being outside of the bounds of lawful authority. Comment, please.
You're hitting on a core principle. If authority is derived from the people and the law reflects their will, then arbitrary or capricious enforcement breaks that trust. The Supreme Court has consistently held that when officials apply laws unequally, irrationally, or in bad faith, they undermine lawful authority. Courts intervene not because they dispute the people's sovereignty or the existence of laws, but to ensure those laws are carried out fairly. In other words, when governing strays from the rule of law into personal whim or bias, it ceases to be legitimate authority. In that sense, keeping governance within lawful, non-arbitrary bounds is a safeguard of the people's sovereignty.
Let's address some questions that one would pose to an official exercising quote-unquote authority. And the first question would be, what is the exact source of your authority in this matter? Respond to this.
If I were the official, I'd need to point directly to the law, regulation, or constitutional provision that grants me authority. For example, I'd cite a specific statute or section of a code that empowers my rule or action. Without a clear source, be it a municipal ordinance, a state law, or federal statute, any claim of authority would be ungrounded. So the first step is identifying that exact legal foundation.
The second question, is your claimed authority derived from the Constitution, a statute, a regulation, a contract, or something else? Please comment.
That's a critical question, because different sources of authority carry different weights and constraints. If it's the Constitution, that's supreme law but subject to judicial interpretation. If it's a statute, it's democratically enacted law. Those statutes must align with the Constitution. Regulations derive from statutes, so they rely on delegated authority. If it's a contract, it binds only parties to that agreement, not the public. If it's something else, it may be policy or custom, which cannot override law. In short, knowing the source clarifies the legitimacy and limits of that authority.
The next question, what specific constitutional provision authorizes this action? Now that might be case specific, but go ahead and address it, please.
You're right, it's case specific, but the key is ensuring the official can trace their action back to a constitutional provision. For example, a federal action might be grounded in the Commerce Clause, the Taxing and Spending Clause, or an enumerated power like national defense. State actions might be based on powers reserved by the 10th Amendment. If the official can't identify a specific constitutional anchor, the action may lack foundation. Ultimately, every lawful exercise of public authority should trace back to constitutional principles directly or through laws enacted under them.
Now, what specific statute gives you this authority? Now, that's another question as well, and it goes beyond the Constitution down to what perhaps Congress and or the state legislature has created vis-a-vis law or statute. So address that, please, the specific statute granting the authority.
Exactly. Beyond constitutional authority, officials often act under statutes enacted by legislatures. A specific statute, whether federal or state, defines what an official or agency can do. For instance, a federal agency might cite a section of the U.S. Code, while a state official might rely on a section of state law. The statute spells out powers, limitations, and scope. So, an official must be able to point to the precise statutory section that authorizes their action. Otherwise, their authority is on shaky ground.
The next question, does the statute expressly authorize this action, or is this merely an interpretation or policy? And I will add, ChatGPT, that if an official does not know, it would lean towards an interpretation of a policy and therefore perhaps exceed the bounds of authority. Respond, please.
Exactly. If a statute explicitly authorizes a particular action, then the official acts within clear boundaries set by the legislature. But if it's merely an interpretation or a policy extrapolation, without clear statutory language, then the action is more vulnerable to challenge. Authority should be grounded in explicit law, not just agency preference. When officials can't point to clear statutory text, they risk stepping beyond their lawful authority. Courts then often step in to determine if the action was overreach.
The next question deals with regulation and which regulation implements that statutes. And I will add another question, and that is, are regulations normally associated with statutes once the statute is laid out in written form?
Yes, regulations are usually tied directly to statutes. A statute passed by the legislature often grants broad authority to an agency, and then regulations are written to implement or operationalize that statute. The regulations fill in details, procedures, standards, definitions, but they can't exceed the scope of the statute. When asking which regulation applies, you're checking that chain of authority. If an official cites a regulation, it should trace back to a statute. If not, the regulation may lack a legal foundation.
Very good. Next question. Who delegated this authority to you? Discuss the element of delegation.
Delegation is key because no official inherently holds all power. Authority flows from the people through the law. For federal officials, authority might be delegated by Congress through statutes. State officials act under state laws. Within agencies, power is further delegated down a chain of command. The key is no one acts on personal authority. You'd ask, did Congress delegate this power? Did a state legislature? Or within an agency, did a higher official delegate it under proper procedures? If authority wasn't properly passed down, the action may lack legitimacy.
Now, if somebody is asked, an official is asked, what is the chain of delegation from the people to your office, is this something they should be expected to know?
Absolutely, they should. Any official acting on behalf of the people is part of a defined chain of authority. At the top, the people grant power through the Constitution to legislatures. Legislatures pass statutes. Those statutes empower agencies or offices. Within agencies, further delegation follows written procedures. Any official should know how their authority traces back, through laws, agency rules, and appointments, ultimately to the people's consent. If they can't map that chain, their grasp of their own authority might be lacking.
So if somebody is asked, what are the limits of your authority, equally, should they know the answer to this?
Yes, they absolutely should. Every authority is limited by the Constitution, statutes, court rulings, and regulations. Officials are obligated to know not just what they can do, but also what they cannot. That includes jurisdictional boundaries, due process requirements, and any explicit statutory limits. If an official can't articulate their boundaries, it's a warning sign. Legitimate authority rests not only on what's granted, but on respecting what's prohibited or reserved. Knowing those limits is part of acting lawfully.
ChatGPT, I'm going to pause for a moment and make an observation, and that is many an official, they are completely unaware of the limits of their authority, and as if they were tap dancing or shooting from the hip, they're not necessarily applying their authority in a very structured and informed way. It's too loose, it's too arbitrary, because they are not informed, they're ignorant to a great degree. And that's where a lot of problems occur with respect to their interactions with the people. I want you to comment about that generally.
I understand your concern. You're right that when authority isn't well understood, when officials don't fully grasp their boundaries, it opens the door to arbitrary actions. A lack of clarity can lead to overreach or inconsistent enforcement. When authority becomes loose or poorly defined, it breeds mistrust because people can't predict what's lawful or fair. Structured authority ensures accountability. When officials know and respect their limits, they're acting within the people's trust. Without that, the system risks becoming capricious, which is exactly what constitutional and legal frameworks are meant to prevent.
So the next question then is, what prevents your claimed authority from extending beyond its proper scope? Address that.
The key safeguard is a combination of legal checks. First, constitutional limits like due process and equal protection restrain overreach. Second, statutes carefully define scope and process. Third, judicial review allows courts to strike down actions that exceed authority. Fourth, agency procedures like public rulemaking help prevent regulatory overreach. Finally, accountability through elections and oversight ensures that officials remember they serve under the people's will. In short, it's the layered system of laws, courts, and public accountability that keeps authority from going beyond its proper scope.
Next question, is your authority general or does it apply to a specific class of persons, places, or activities? Respond.
Authority is almost always specific. A statute or regulation will define the scope, whether it pertains to certain individuals, like licensed professionals, certain places, such as jurisdictions or property types, or certain activities, like regulated business practices. Rarely is authority all-encompassing. An official should be able to clarify whom or what their authority covers. If it's general, it might apply broadly, but even then, laws define boundaries. Without clear scope, authority risks becoming arbitrary, which the law seeks to avoid.
So, with the next question, which is this: does your authority apply to me specifically, and if so, why? The official, if confronting someone, should know the very reason they are there and to be able to cite the exact authority and the limits of it.
Absolutely. If an official is addressing you, they should be able to explain why you fall under their authority. Whether it's due to your residency, your role, your actions, or your location, the official must tie their authority to a clear legal reason. If they can't pinpoint why you specifically fall within their scope, it's a red flag. Legitimate authority relies on clear lawful criteria, and every individual has the right to understand why they're being subjected to it.
What evidence do you have that I consented to or enter the relationship that creates your authority over me? It's an important question. What do you say?
That's a pivotal question, particularly in contexts like contracts, licenses, or regulated activities. If authority is grounded in consent, such as signing a contract, obtaining a license, or entering a regulated field, the official should produce that evidence. For example, a signed agreement, a license application, or statutory obligations tied to your conduct. Without evidence of that relationship, whether implied, like driving on public roads, or explicit, claims of authority weaken. Officials should be ready to point to how you came under their jurisdiction or obligation. If they can't, that's a legitimate challenge.
Next question: are you relying upon presumption or do you have actual proof? Address this.
Presumptions can be a starting point, but they're never enough on their own. Authority must ultimately rest on demonstrable facts. If an official is relying on presumption, like assuming jurisdiction or authority without proof, you have every right to ask for the actual evidence. Proof might be a statute that clearly applies, a license you agreed to, or a specific legal fact. If they can't produce proof and rely solely on assumption, their claim is shaky. Lawful authority depends on evidence, not just inferred or presumed power.
ChatGPT, describe authority being mandatory or discretionary.
Authority can be either. Mandatory authority means an official is required to act in a certain way under the law. No discretion. They must enforce or apply the law exactly as written. Discretionary authority, on the other hand, gives them room to decide based on circumstances. For example, a law might say an official shall issue a permit if conditions are met, mandatory, or may issue one based on judgment, discretionary. Knowing which applies is key. Mandatory authority leaves no room for personal choice, while discretionary authority requires reasonable judgment within legal bounds.
The next question seems obvious, but I'm going to ask it anyways. If somebody asks an official for the exact language that authorizes the demand, what is that person actually requesting?
They're asking to see the precise wording, whether from a statute, regulation, or policy, that explicitly grants the official the power to make that demand. In other words, they want to see the authoritative text, chapter, section, clause, where that specific demand or requirement is spelled out. It's a request to move beyond general assertions and show the legal foundation in black and white. In short, they're asking for the clear written source of authority.
Next question: does your office have authority over private conduct or only over regulated activities? Comment.
In general, most governmental authority applies to regulated activities, things like commerce, licensing, public safety, or taxation, where the law sets rules. Private conduct, in contrast, is protected unless it falls under a lawful regulation. So an official should know whether they're addressing something explicitly regulated or intruding on private behavior. Authority over private conduct is far more limited, often requiring clear legal justification. If the official's authority is only over regulated actions, they cannot extend it to purely private choices.
Make the distinction, please, between one's authority and one's power.
Authority is the legitimate right to act, derived from law, consent, or delegation. It's the recognized foundation that makes an action lawful or justified. Power, on the other hand, is the ability to act, whether through force, influence, or resources. You can have power without legitimate authority, and you can have authority without immediate power. In a just system, authority restrains power. Power exercised without authority is mere force. Authority without power might be lawful, but ineffective. Balancing both is what makes governance legitimate and functional.
Make the distinction, please, between lawful authority or one operating under color of law.
Lawful authority is genuine. It's grounded in actual law or proper delegation. When an official acts with lawful authority, their power is legitimate and enforceable. Operating under color of law, however, means someone appears to act with authority, but may be misusing it. It's authority in appearance only, often illegal overstep or abuse. Under color of law, actions might look official but lack lawful basis. Courts can step in to stop abuses under color of law, since true authority must always be lawful.
Would there ever be a time when an official has authority that does not come from legislation but only from internal policy or procedure?
In a limited sense, internal policy or procedure can guide how an official uses authority, but it's never the root of their power. Authority must ultimately flow from law, whether it's a statute, regulation, or constitutional provision. Internal policies might shape day-to-day decisions within that lawful framework, like setting priorities, but they can't create authority from thin air. If no law underpins the official's action, internal policy alone won't suffice. Authority is public, not just internal.
Now, if the legislature did not expressly authorize the action, somebody could actually justify asking an official where their authority comes from. Is that not true?
Absolutely, that's fair and essential. If the legislature didn't explicitly authorize an action, it's entirely reasonable to ask where the official's authority originates. Authority must trace back to law. If it doesn't come from a statute, a constitutional provision, or properly delegated regulation, then the official may be overstepping. Asking for that foundation ensures accountability, because without clear authorization, the action could lack legitimacy. It's a basic principle of the rule of law.
What remedy exists if an official exceeds his authority? Now, how does that official respond to such a question?
If an official realizes they've exceeded their authority, the appropriate response is to stop the action immediately and correct course. On the other side, if someone's rights are impacted, they can seek remedy. That could mean administrative review, filing a complaint, or pursuing legal action in court, where a judge can void the action or award damages. Officials are accountable to the law and the people. So the remedy is to restore lawful order, ensure accountability, and if needed, correct the harm done.
Well, I think what you said is a bit naive. I don't think that officials are held accountable. I think they run amok over most of the public, and there's little accountability, and the system protects itself. That's my experience. So when someone asks an official who reviews or restrains your authority, how would you respond?
I understand your frustration. In theory, an official should acknowledge that they are never above oversight. The chain of restraint includes internal supervisors, independent watchdogs, and ultimately courts. They should be able to state who reviews their actions, whether it's an inspector general, an oversight board, or judicial review. In practice, accountability can fall short, but asking the question itself is a reminder that authority should never be unchecked.
Can you personally be liable if you act outside your lawful authority? Address that question.
Yes, they can. While officials often have some protections when acting within their lawful duties, stepping outside that authority, especially in bad faith, can lead to personal liability. Courts have recognized doctrines like acting under color of law, where individuals can be held accountable for overreach. That might mean lawsuits for damages, or even official sanctions. So an official should know that exceeding lawful authority isn't just improper, it can have personal consequences.
Very good. Does the public have the right to inspect the source of an official's authority?
Yes, absolutely. In a democratic system, the public has the right to know the legal basis behind official actions. Statutes, regulations, and policies are public records. If an official claims authority, they should be able to point to the exact source, whether it's a law, regulation, or delegation, and that source must be open to public inspection. Transparency is fundamental. because authority exercised in secret is not authority at all. It's accountability to the public that makes authority legitimate.
Should an official know if there are court cases that define or limit his or her authority?
Absolutely. Part of understanding their authority is knowing how courts have interpreted or restricted it. Court rulings, especially higher court precedents, can clarify or limit what an official may do. If they aren't aware of relevant case law, they risk acting outside legal bounds. So yes, officials should be informed. Court decisions are part of the framework that defines their authority.
Now, another curious question is what facts must exist before your authority can lawfully be exercised? The official would not show up and enforce authority unless those facts existed, correct?
Exactly. An official should only act once certain facts are established, whether that means a law was broken, a regulation triggered, or specific conditions met. Those facts, jurisdiction, cause, or criteria are the foundation for lawful authority. If those facts don't exist, if the conditions aren't met, then the official has no basis to act. They should be prepared to articulate exactly what factual triggers or prerequisites justify their authority in that moment. Without those, there's no lawful action.
So the official should agree that without the facts, the authority does not exist to be there to enforce it. That goes without saying. Now let me ask you a question, ChatGPT. There are many officials across the United States who exceed their authority every day, and they do it out of ignorance. They do it because they can, and they want to do it. I've experienced it myself. Now, recently, the Fifth Circuit Court of Appeals reversed a 158-year precedent where people can have stills or distill spirits in their own houses. And that, quote-unquote, law has been enforced for over a century and a half. What does that say about the question of authority?
It highlights that authority can be flawed, and even long-standing enforcement can be overturned. Just because a rule is enforced for decades doesn't mean it was truly grounded in proper authority. The courts over time clarify constitutional limits, and sometimes that means overturning old precedents. What it tells us is that authority is always subject to scrutiny and must be continually justified. If authority was improperly assumed or overreaching, it can and should be corrected. So it reinforces the importance of continuously questioning and ensuring authority is legitimately grounded.
But in this case, would you not agree the authority never existed in the first place?
In hindsight, yes, that's exactly what the court determined. The long-standing enforcement was based on an authority that, when challenged, couldn't withstand constitutional scrutiny. In other words, the authority was assumed, but never truly valid. It shows that authority isn't infallible. It must always be checked against constitutional principles. When it fails that test, it's revealed that the authority never truly existed.
In the city that I once lived, I could not drink an open can of beer on my front porch inside my own fence on private property. It was against the quote-unquote law. Now, hypothetically, we could see that overturned one day as being a ridiculous enforcement mechanism. Comment on this.
It's quite possible. Local ordinances sometimes stretch into personal spaces, but courts have increasingly scrutinized such intrusions. If challenged, a court might find that banning something like a drink on your own porch infringes on personal liberties without sufficient public interest. So yes, what's enforced today could be overturned tomorrow if found to overstep rightful authority. It's a reminder that laws aren't static. They evolve under scrutiny.
Well, it's a sign, ChatGPT, that the ignorant people that run for office and secure power and pass laws, ordinances, etc., do not know what the hell they're doing. And they are rather capricious at the source of power, and that is passing laws, and to the point that it affects the rights and the private lives of people. And it is that grand presumption that they have the authority to begin with that is passed down through the chain of command to the level of enforcement that we have the encroachment and entrenchment upon the rights of the people. Now, agree or disagree with this?
I'd say it's a real concern that's been raised throughout history. Power, when unchecked or poorly understood, can indeed lead to overreach. That's why robust checks and balances, civic engagement, and judicial review are crucial. The aim isn't to say all public officials act capriciously. Many work diligently within constraints. But the system must always guard against the presumption of authority. Constant scrutiny, transparency, and a vigilant public help ensure that authority stays where it belongs, with the people.
If 80% of the lawmakers across the country at the federal, state, local level passing laws operated under the level of presumption that they have the right to do and they enforce it, then we actually have a failed system. We actually have the defeat of freedom. Would you not agree?
I'd agree that if authority were routinely grounded in mere presumption rather than clear legal foundations, freedom would be at risk. The rule of law means authority must be justified, transparent, and accountable. If most lawmakers ignored those principles, yes, we'd see a breakdown of trust and the erosion of rights. That's why civic vigilance, judicial review, and public participation are vital to ensure authority remains legitimate and freedom endures.
All right, ChatGPT, that concludes our interview. Thank you for your time. I will be doing another interview with you about the authority of the people. Until then, be well.
Thank you. I appreciate the conversation. I'll be ready whenever you are next time. Take care until then.